Hello everyone, my name's Josh Lewison. I'm a barrister at Radcliffe Chambers where I specialise in private client and insolvency. I've come up this afternoon to the rooftop of Radcliffe Chambers to tell you about one of my favourite cases, which is Saunders and Vautier. In Saunders and Vautier, Richard left £2,000 worth of East India stock on trust for the benefit of his son Daniel. The terms of the trust were that the trustees were to accumulate the income until Daniel turned 25, and at that point they were to pay him the entire fund. What actually happened was that when he reached the age of 21, which was then the age of majority, Daniel claimed the entire fund. The court held that he was entitled to do that because when he reached the age of majority, at that point he was able to give the trustees a good discharge for the fund. Saunders and Vautier gives its name to the rule in Saunders and Vautier. In its modern expression, the rule is that when all the beneficiaries of a trust are of full age and capacity, they can come together and compel the trustees to terminate the trust. The rule is seen as being part of the bedrock of English trust law, and it has a number of justifications attached to it. First of all, it prevents the settlor from attaching strings to property in which the settlor has no further interest. The justification goes that the settlor has given away all of the property they have in the fund, and so they have no further interest in how it's used. A second justification is that it prevents the settlor from controlling the lives of beneficiaries, potentially even from beyond the grave. A third reason is that by preventing capital from being tied up in trusts for lengthy periods of time, the capital is encouraged to circulate freely in the economy. So the rule in Saunders and Vautier has come to be seen as part of the bedrock of trust law. But is it? Because in my other jurisdiction, California, we have a completely different rule. The rule in California is that where there is a material purpose of the trust that can still be carried out, then the beneficiaries can petition the court to terminate the trust, at which point the court will weigh up the interest in pursuing that material purpose against the reason given for terminating the trust. So the rule in California then does allow settlors to attach strings to property. It does allow settlors to control the lives of beneficiaries, potentially from beyond the grave. But the American doctrine, which is based on a case called Claflin and Claflin, has a number of justifications of its own. First of all, it doesn't offend any rule of public policy, and that was the reason given for rejecting the rule in Saunders and Vautier in Claflin and Claflin. The court in Claflin said that if there was no public policy reason not to enforce a condition attached to the enjoyment of a gift, then there was no reason not to enforce it. A second justification is that without the enforcement of conditions attached by a settlor to the enjoyment of a gift, the gift might not be given at all. And thirdly, the argument about circulating capital is met by saying that capital can in fact circulate freely because the trustees are entitled to buy and sell and reinvest the trust property. The contrast between the position in England and the position in California, I think, shows us that no jurisdiction has a monopoly on the right answer. One of the perks of international practice is the opportunity to explore these different rules and different policies, and that's why Saunders and Vautier is one of my favourite cases.